Good morning. Welcome to webinar number 4 that the District Facilities Branch is presenting. Today's topic is Property Part 2. Previously presented Property Part 1, which focused on acquisition. Today, we're going to discuss what you do with property that you own. Next slide, please. Here's a summary of our presentation, introductions, definitions that will be applicable, constitutional implications of property, statutes, legal acts, regulations, best practices, frequent issues, general discussion, and questions. As a housekeeping matter, we've got quite a lot of content today. I'd like to take your questions using the question and answer feature, but we will defer answering questions until the end of the presentation. Next slide, please. Dr. Robbie Fletchers, Commissioner of the Department of Education. Next slide. District Facilities Branch is located in the Office of Finance and Operations. Matt Ross, the Associate Commissioner. Within that office is Division District Support. Jay Ritter is the Division Director. Marshall Smith is the Assistant Director. Next slide, please. My name is Greg Dunbar. I'm Manager of the District Facilities Branch. I've been with KDE now for a little more than 16 years. Next slide, please. Within the branch are 4 design professionals. Gary Least has been with us the longest. He's pushing 17 at this point. Each of our project managers are assigned approximately 1/4 of the 171 school districts. Gary's districts are listed on the slide here. Full listing of project managers and their assigned districts is on our webpage. Next slide, please. Marcus Highland, like Gary and I, is an architect as well. He's been with us for 9 years. He has extensive experience prior to joining KDE while working with an architectural firm that provided primarily K-12 design services. Next slide, please. Next, John Gilbert, also an architect. He's been with us 6 years and, like Marcus, has extensive K-12 experience prior to joining us. Next slide, please. Reese Hester, certified interior designer. She's been with us 3 years. She had a lot of experience in state government before joining us, significant experience with property, and her districts are listed here. Next slide, please. The 6th person in our branch is Tanisha Keene. She's our analyst. I describe her as the glue that keeps us together. She is our fact-pack guru. So she is the primary contact for all technical issues regarding fact-pack, which is our SharePoint application used for facility planning and construction. Next slide, please. So some definitions from the primary topic today, which is surplus property from Section 1. Everybody's familiar with the term district facility plan. We've talked about fact-pack already. BG1 project application form is a form used to initiate, revise a capital construction project or property transaction. BG5 is project closeout form. It's used to close out a capital construction project or property transaction. Fair market value, very important terms, the value of real property based on appraisal performed by a real property appraiser licensed to practice in the Commonwealth of Kentucky. And survey, that's a formal assessment of real property that's sealed and signed by a professional land surveyor that provides information regarding the property lines, the size of property. Next slide, please. Other relevant definitions that are not included in the regulation: appraisal. That's how fair market value is determined. Easement is a property right granting a limited legal right to cross or otherwise use someone else's land for specified purpose often requires compensation due to the lack of or the loss of the use of the property for which the easement's being granted. Lease, as used in the regulation, means a contract between the local Board of Education and another party for the use of district property or portion thereof for a specified term, usually a year or longer, in exchange for specified compensation. Real property, land and anything permanently attached to it, such as buildings and fixed equipment, natural resources within the substrate like minerals, and the airspace above it. Personal property, movable, not permanently fixed equipment, such as desks, computers, and so forth. Modular classroom units are considered to be personal property. Transitional center is a term used in the planning manual, and transitional centers have no reported need on a district facility plan. Next slide, please. The Constitution of Kentucky and multiple Attorney General opinions related to sections 180, 184, and 186 address the use of the taxes that are levied and collected for the benefit of public education. The Constitution, statutes, opinions of the Attorney General, and case law can be found in the Kentucky School Law Book on the KDE website. The most recent version was posted this week. Next slide, please. Next, statutes. There are multiple statutes that deal with various aspects of property. This particular statute, KRS 45A-425, deals with personal property, which we've already said is not real property. KDE does not administer the disposal of personal property. You should refer to your local Board of Education's adopted policies. KSBA has a template that relates to both real and personal property on their website for your use. Next slide, please. This is important too. District Facility Branch administers leases for which the district is the landlord. When a district is a tenant, those leases are administered by the Office of Legal Services, and you should contact Todd Allen for further direction on that. Next slide, please. This is a relatively new statute. It deals with the sale of property from a board to a governmental or quasi-governmental agency. When 702 KR 4:090 was revised, we included these transactions so that we can record them and keep track of them. Next slide, please. KRS 160.293 talks about development of school property for recreational facilities for school and community purposes. Boards of Education can cooperate with a public agency to develop and maintain recreational facilities. However, the use of the property shall not interfere with school activities. And the control and management of such facilities shall be in accordance with KDE regulations. Proposed agreements must have the prior approval of the Chief State School Officer, the Commissioner, and the Attorney General. This provision for recreational facilities is also addressed in 702 KAR 4:005. Next slide, please. KRS 162.055, use of school property for recreational, sporting, academic, literary, artistic, or community uses. This basically, in my opinion, is like districts renting gyms on Saturdays for basketball leagues or something like that. It's not a long-term constant use of a facility. Next slide, please. So, legal notices, Chapter 424, sometimes called bid law, addresses legal notices, advertising, and proof of publication. So KRS 424.130 talks about the times and period of publication. So if you're advising the public that they can submit a bid, it must be published at least once, provided that one publication does not occur less than 7 days or more than 21 days before the occurrence of the act. And so in terms of the content of that advertisement, shall describe what is to be bid or sold, time and place of the sale, or for the receipt of bids, and the special terms of the sale. Next slide, please. KRS 424.145 is also relatively new in that it provides for alternative internet newspaper publications procedures. My understanding is that it's sort of population based and to provide some kind of generalized statement as far as how that might apply to a specific district. I think is outside the scope of this. The district should consult with its legal counsel to determine if it's applicable to your particular situation. KRS 424.170, proof of publication. That is a statutory requirement when you're advertising for bids. Next slide, please. Legal acts. Most everyone is familiar with House Bill 678, passed by the 22 regular session. It expired June 30th of 2024. However, it was extended by House Bill 727, 2024 regular session to June 30th of 2027. And how it relates to today's conversation is that the commissioner or designee shall approve or disapprove a complete request for disposal within 30 business days of a complete transaction. It also specifies that a disapproved request may be appealed to the Kentucky Board of Education. Next slide, please. Okay, regulations. Touched on recreational facilities earlier. Next slide, please. Before we get into the meat of the presentation, which is surplus property. Surplus property also relates to 702 KER 4:0500 building sites inspection approval, which provides for limitations regarding hazards to health and environment. So if you dispose of property, you should not be creating a situation which creates such hazards. 702 KER 4:170, facility programming construction criteria have requirements related to site development, and specifically school facilities are to be located at least 200 feet away from any source of air or water contamination and high pressure gas lines. So any actions that would create this situation should be looked at very carefully. We have been tasked with revising regulations. This specific one, we've looked at the 200 feet. We think that that may be adjusted upward based on the volume and the pressure of the gas line. Excuse me. 702 KER 4:180. It's where we find the definition for transitional school centers that we talked about earlier. Next slide, please. 702 KER 4:090, disposition process. This regulation became effective December 10th of last year. One of the primary things that it did was it moved the submittal of all documentation into FactPack. John Gilbert and Tanisha Hester have been involved in this transition. At this point, I'm going to turn the presentation over to John. Thank you, John.
Thanks, Greg. Like I said, I'm gonna go over 702 KR 4:090 and kind of get a little bit more into the weeds. And the next several slides are going to focus on 090. We're also going to focus on FactPack, which is a different component. That in the past, disposal was not part of that. The department is required to keep track or have, because of vested interest, documentation of deeds, whether you acquire property, which has been in FactPack, and you give us that final deed and title insurance. But on the flip side, like we're going to talk about today, when you're getting rid of property, we need the acknowledgement and the paperwork of when you get rid of that old school or that old piece of land. So it's kind of the flip side of that, if you will. So I'm breaking this down section by section, and the first section Greg's already shown you, which was the definitions. Section 2 goes over the disposal process. There's 6 fundamental items here that, whether you're doing a lease, an easement, or selling a property, these 6 things you need to keep in mind for all of them. Um, you need to declare the property surplus to the educational needs of the district, whether it's for a property that you're selling and getting rid of in its entirety, or an easement, whether it's a little 2-foot strip, or 2-acre area that the utility company is using or some other entity is using. That section needs to be declared surplus. Get with your attorney on language that you at local policies may need, but this language will constantly show up through part of the submittal processes as well, going through. Item 2, um, you know, all of these do require, even though we have 678 from construction, you don't require approval from us. All property still requires approval from the Department of Education, whether it be um, contingent approval, which goes in item 3 here, or final approval before you sign that dotted line and getting rid of that particular property, or the closeout documentation for us. Once you have those documents signed, we are required by law to actually have the signed documents in hand, that deed in particular. So, part of that BG5 process, to kind of sum up everything I'm getting ready to go over, when you send in that BG5, you'll be sending in the signed agreement at the end, or some variation of that, depending on if it's a lease, an easement, or um, actually selling the property. Also, keep in mind that all documentation, these are legal documents. The source documents are at the local source. So when you're signing these agreements, we are not attorneys. You've probably heard me, if you've talked to me on the phone, you probably heard me say that 400 times. Have your legal counsel review documents to make sure that they're compliant from a legal standpoint. Your fiscal agents should also be looking at those things, and your insurance carriers. I'm sure you want to relieve yourself of certain insurance liabilities and costs, for that matter, along the way. So keep those things in mind as you move forward from a regulatory standpoint. Also, federal funds. State of Kentucky, when it comes to capital construction and property, doesn't typically deal with federal funds until, unfortunately, COVID came around. We've had a lot more federal funding. If you have federal funds that are tied into that project, or you did something during ESSER, or you have other funds related to federal, some of those fund requirements, I'm not going to get into it here, but we do mention it in this particular item. This is the one time you're going to hear me talk about federal. This is have requirements that if you get rid of that property, you may have to pay back the federal government, or you may have to relinquish that property to them. I don't know all the details you have. That's a case by case basis. That is a federal fund source by federal fund source basis. We're not going to pretend to know what those requirements are, but do be alert, be attentive to it, and also let us know as you kind of move through that process. Some we may be able to help you, others you may have to defer to your attorney, or others that might have federal program related experiences, and we'll try to help you get to those people if there are some here at KDE. Also, to kind of go back to the 678 that Greg mentioned, 30 business days. We've written that into the regulation that was approved back in December of 2024. So 30 business days, when you get a complete submittal, the expectation from the district should be that we get something back to you. We hope to turn those things around sooner, but we are trying to uphold ourselves with that, maintain that in the regulation. Before I get into the next section, which is about actually selling the property, This is a big shift for disposal of property. If you've received contingent approval and you're still working on something, we might look at the old reg for things that are actively in that. But if you're new, starting to get rid of a property after December 10th of 2024, you need to create a BG project and upload information into the system. We expect a BG project number and a BG1 and a BG5 through the systems for record keeping and also approvals, contingent approvals, final approvals, and closeout. So one other thing that a lot of you might be familiar with, and this is why I have this slide on here, this is the homepage that a lot of school districts see, and you might hear us with the language of uploading under My Document Submissions. A lot of the times when you send BG1s, you like to attach the information to the BG1. This is a big shift for some people. We don't really want you for property-driven items. We need you to upload under My Document Submissions your deeds and the submittals that we need to review. It's a tiny bit more work on our end when we see a BG1 come through to kind of go back and forth, but for the benefit of the program, the benefit of the requirements of the department needing to keep this and retain this information for a long time or forever in theory, if you will. And it isn't something that we dispose of 5, 7, or 10 years later. These deeds and final agreements we keep until such a time that you dispose of or whatever. And part of these documentation property wise, we're supposed to always keep that. The flip side of acquiring is also disposing. So keeping that documentation is important on our end. So I just want to kind of emphasize that here. This is an important shift in what a lot of you FactPack users are accustomed to when it comes to BG forms. So with that being said, I'm going to get into the meat of the regulation itself. This language is kind of word for word from the regulation that you'd see on the LRC website. I'm trying to highlight the items that I'm going to go over as we go through. But Section 3, we've moved from Section 2 that I've just told you about, the fundamentals of all disposals, into Section 3. If you're going to actually sell a property, you're going to want to look at Section 3 in addition to Section 2. So Section 3 starts by the disposition sale. You need what's called contingent approval. Contingent approval means that you're basically acknowledging to us that you're going to sell a particular property. And to do that, in the past, you would receive a letter from the department or from our branch giving contingent approval to move forward and enter into those negotiations or, auctions or what have you to sell the property. Now that contingent approval is through the approval of the initial BG1. So you would need to send in an initial BG1, identify the basic information from that property, an address or some type of property description. Sometimes you occasionally don't have addresses, so getting survey information or deed information, something relevant and tangible to identify that particular property. Address is 90% of the time usual, but on occasion we have one that didn't legitimately have one. Your current official reported name in what we call the DASCAR system, if you're not familiar with that, most of you should be. That's the repository of information on official schools. That's particularly important if it's a school building or if it's something that you've reported as a physical structure. You might have property that has nothing to do with that, and that's okay. But when you have an actual old school that you're getting rid of, we want to make sure that all that's reported accordingly. And then any kind of acreage or square footage for that matter, if it's a building. Like I said earlier in Section 2, a declaration of surplus. We are trying to put on the BG1. I don't know if it's fine-tuned, but when you go through checking all the boxes on a BG1, we're trying to resolve a declaration of surplus be on that form so that when the declaration is checkbox there and your board is approving the initial BG1, you're kind of simultaneously doing that. You'll want your attorney to double check and make sure that the language is appropriate, but if they're good on a case-by-case basis, or if you're some districts that have multiple properties, and I've seen one or two of our guests here today that I know have done several properties for a variety of reasons that I've worked with, you're going to want to make sure that that's good from on all your cases. And then also, this one doesn't come up very often, and we're not going to ask for this information, but it could be vitally important that resolving mortgage liens or other encumbrances. Please put that in there if it impacts the sale of that. If it doesn't and we don't receive that information, we're not going to ask for it. We're going to assume that that's a non-issue for that particular item. So you have to make sure that that stuff is resolved. So we provide the contingent approval through the initial BG1. I do want to point out BG1s usually have a lot of dollars, especially in capital construction. You have millions of dollars and you list all these costs. From a disposal and property standpoint, the initial one could say $0. We realize that you're in a negotiation phase. You don't necessarily have your fair market value and you may not have your appraisal yet. You're just wanting to get started and acknowledge with us through the reporting of this and getting a board approval that you're starting this process. You're getting contingent approval to move forward in documenting this whole process. So continue on in section 3, the next item on that, once you've received your contingent approval, your board is going to want to, or your administration, I should say, needs to make a determination alongside your board of how you're going to sell that property. So item 2 in the regulations, are you going to do this by public auction, sealed bid, or minimum acceptable price? Those are the 3 options in regulation that you're that you have under consideration. 2 of those have the similar requirements of submittal that when you send everything into us. The 3rd one, the minimum acceptable price, has a different set of functions. So as we get through that, you're going to notice that in the language that kind of parallels, it's almost, the regulation almost becomes a checklist for you as you kind of go through that process. So the method of sale chosen determines the next steps, as I kind of note out there. And all of these methods should provide what is considered a fair market value. And ask your project managers if you have problems along the way about what that is. We can deal with that outside of this particular presentation. That's a popular issue that kind of comes up in public auctions. So in item 3 of section 3, when you consider item 3, 4, and 5 deal with public auctions and sealed bids, not minimum price where you're talking to an individual, but anything that you have to publicly advertise basically through the auction or sealed bid process. Items 3, 4, and 5 are specific to you under section 3 of the regulation. So when you have received the bids and you've advertised and you've got an agreed upon price that's meeting that fair market value, you send in a revised BG1. At this time, you're going to have an actual cost, or it's not really a cost. You're going to be getting that money, but you would fill out your BG form and say, okay, I'm going to be getting this property for $100,000. The fair market value in the appraisal says $100,000 is acceptable. Whatever that is, the revised BG1 approved by your board would come into us as underlined there that you see under item 4A, the appraisal that would support the fair market value of that particular item, the published legal notice and affidavit for the publication. Because you've done it through a public auction or sealed bid, it is required not just from this regulation, but statutes that are kind of beyond our control, is also part of that approval to know that you have done that. The results of the public auction or sealed bids, what some people know as bid tab, and then the proposed sale agreement. Now that you've got a bid that you're good with, get with your attorney, have the proposed unsigned agreement available for our review. So send in items A through E alongside that revised BG1. We will review these things, and the approval through FactPack of that revised BG1 is your approval to go ahead and sign on the dotted line. It's often called the final approval. It is the final approval to sign the agreement. It's not closing the project out. It is the final approval so that you can go ahead and purchase the property. I know sometimes the language and the lingo kind of gets there as you kind of move forward. And then the revised, so anyway, let me kind of move on here. And so the other option, you'll notice the screen gets a lot cleaner here. Minimum acceptable price. So if you have some adjoining neighbor that wants to buy that piece of land between the school district and their property or whatever the case may be, there is an option to sell to a singular buyer. But for that, you would need to send in the revised BG1 with the approved cost that the board has approved, supported by an appraisal, which gives you the fair market value, and the proposed unsigned sale agreement. We review these things, the approval of that revised BG1 with the associated value, and subsequently the funds that it would go into, almost all the time would be general, by the way, um, would signal that you could go ahead and complete and actually sign that agreement. So once you get there, as we start to close out section 3 here, regardless of the type that you're selling, once that revised BG1 is approved to go ahead and sign the agreements, you send in the executed signed final agreement alongside a signed BG5, and that will close the project out for you. That, in a nutshell, is actually selling the property. Also, by statute, and I think Greg mentioned this earlier, you have the governmental to quasi-governmental. We as KDE do not approve the government to government per statute, but we still, because the state has a vested interest in property, we need the documentation of that closeout. So when you send this in, think of this as 678 districts or 727, that we need an initial BG1 with all the documentations uploaded under My Document Submissions sent to us alongside that BG1 for record keeping and data collection. We don't make approvals, but you do need to send in to us the appraisal and the signed agreement between yourself and KYTC or the local government or some governmental or quasi-governmental. You're basically going through the process for record keeping and documentation, and that's through one BG1 and one BG5. The
Don,
BG5 simply closes it out. Yes, Greg?
this is not mandatory, but it is an option. The government to quasi-governmental agency is an option that districts can use. It's not mandatory.
Oh, you're
one thing,
saying like for them to actually sell outside
yeah,
of the department.
right,
Gotcha.
right.
Okay. Yeah, it is a requirement for us to get this documentation. It is an option to the district if you want to make the approvals at the local level and not through the department. Did I say that right, Greg? Okay. He is giving me a heads up for those who I think you can see Greg on here alongside me. But anyway, moving forward, so that's section 4. It's just basically a BG1, send in everything, sign in the appraisal, and a BG5 just to simply close it out. We can walk you through the details of BG1 and BG5 for this disposal process across the board. That's maybe another presentation for another day in terms of those details, and might be part or supplemental to an upcoming webinar that we'll have. Disposition by easement. Starting into section 5 now, easements shall not conflict with requirements of 050 and 170. Greg made a very important health safety one, if you will, about the gas lines. There are other requirements in here, and I have additional mentions here. 050, traversing the middle of properties and things like that. We want to be mindful that any kind of easements are along borders and perimeters, not through the middle of the school or through the middle of potential developments in the future. 170 has model program details for schools and also sites and playgrounds and things like that. So keep those things in mind. Your design professionals can help with that. They might not be part of the disposal process, but if you have projects that are kind of working alongside disposals of edges of properties and things, this is a good example of maybe just, I don't know, having the equivalent of spending an hour or two walking through a survey with them to kind of ensure to communicate to your attorneys what that needs to happen or not happen, and also call us about some of these details along the way. Also, disposition by easement, item number 2. This kind of gets down to the actual submittals and the processes through the regulation of what the expectation is. So again, it's an initial BG1 that comes into us. You again declare surplus to the educational needs of the district. For an easement, you own all this property, but you're looking at sections or lines where utility gas lines or electric lines, or maybe you have a roadway to a private entity that has to have access preferably along the perimeter here. You need the one thing you're going to need here that you don't necessarily have as a requirement coming to us is some formal survey, very, defining that strip of land, that roadway or that utility area that you're not going to use for educational purposes for the district. So part of your BG1 is submitting the declaration, submitting the land survey, submitting the appraisal, and the proposed easement agreement for us to look at. You can do this in one BG1 option to kind of send our way. We will review all this as you submit those items, uploading them under My Document Submissions alongside hitting the send button for the BG1. We will look at these things and process that in tandem with that. Also remember, and I have it underlined here, I'm not going to go through all 5 of those items under the easement agreement, but we look at to make sure that those items are there. It's important that you have a reversionary clause in there so that if that utility is no longer in use, that roadway is no longer needed, that the use of that property comes back to you. And then, of course, the receipt of fair market value for that permanent use of that particular one. Kind of want to go on here to kind of move on. Also, section items 3, 4, and 5 of the easement components. If the easement is for exclusive use to the district, you're coming off of a main line and it's for your use, or they relocate those things do not require fair market value. However, if that main utility line going through there serves neighborhoods, the community, the county beyond you, those things do require fair market value, and that's the process we go through. If it's specific for your use, then that's a local level thing and doesn't necessarily have the fair market requirements needed. So keep that in mind as you kind of move forward. To close out easements, once you've gotten the approval, get the easement signed and simply send it in alongside the BG5. This is, again, easements make mention of valuable considerations. It is possible that you won't have monetary value more than its land value or utility value. You want to mention those in the scope in the BG1 if it's something about the value of receiving such items. Greg, did you want to say something to that?
Yeah, I do. The valuable consideration should be able to be quantified and documented so that it can be compared to the fair market value of the property.
All right. Let me move on here. I know we're kind of running out of time, and I do want some time for questions here at the end. Disposition by lease. This again is lessor, the landlord, if you will. Lessees go to the Office of Legal Services, and I've given another email here at the bottom for the larger leases. There's a specific one. If you have smaller ones, you need to contact OLS when it comes to lessee. But we still focus on landlord as lessor. I've seen an example where a school had the public library, if you will, leased their old library while they had another library in the same building for school use, those kind of things. So for this, you would again do a signed BG1, and make declaration surplus to the property that we always have, and that the proposed lease agreement has been reviewed by your local attorney. You would send in that proposed lease agreement alongside that BG1, not just the BG1 itself. All of these have attachments that you upload under My Document Submissions that we need to review alongside that BG form. So keep that in mind as you send it in. Now, what we look at when you send in that proposed lease agreement are these 12 items. I don't know that these have changed, Greg, from the original, and I'm not going to go through those for time's sake, but we look for these 12 items, and this is what needs to be in your agreement. If we don't see these items, we may either call you up and question them, or it might be a disapproval and sent back incomplete, and make these things adjusted so that you can kind of sit it back in and have those terms adjusted. And then once it's approved, the BG5 is merely to have the executed agreement and the closeout in our systems alongside that. There's Section 7 and Section 8. There, in December of 2024, this regulation was approved. In June, July of 2025, a new waiver process has happened. There, you need to get with your project manager to determine if the waiver is something that needs to go through OLS and the state board, or if it is of a minor condition. We want to make sure and be consistent with everybody about what that is. We're trying to clean that up as well. But the intent of that waiver was any kind of minor submittals that were not necessarily a requirement to gain approval along the way. So we will try to clarify that further. Haven't had anybody come across wanting that yet, but we would like you to kind of contact us first before you start to go through that process. Gives us as a department a heads up, and then we can kind of communicate that on up the food chain, if you will, to upper management. Also, Section 8 had disapprovals and appeals process. This kind of goes back to 678. And some of the requirements of, trying to make these in permanent regulations. This is the one regulation we worked on that got through that has some of those 678s on a permanent basis. I mentioned earlier the 30-day. This is on the flip side of that. If you get a disapproval from the department, the option or potential to appeal that disapproval to the state board. Now, that's obviously a longer process, but the 30-day turnarounds and approvals and all that come from the department. The appeals process gives you the option to say, hey, I don't really like what the department has said. I would like to get a appeal. Haven't had anybody had to do that yet, but that option is afforded there through that option as requested through some of those legal acts earlier. And with that, I'm going to turn this back over to Greg to kind of finish this up. We just got 2 or 3 more slides here. Greg?
Thank you. So Section 9 is conflict of interest. Most local boards of education have policies regarding this. Excuse me. But particularly when disposing of property, any conflict of interest should be identified early on. Next slide, please. John has gone over item by item the items required for each particular type of transaction. And once we get all those items, they're considered complete. And that's when the 30-day clock starts ticking as far as our approval and disapproval. Next slide, please. Best practices. Contact your project manager assigned to your district to discuss proposed property transactions early on. Review the current DFP to identify if the property is on the DFP as a transitional center or not listed. If it is on the DFP and has need reported to the legislature, you will have to initiate the appropriate action, meaning a finding or amendment to modify the DFP to remove that need before you can dispose of it. And those processes are provided in the Planning Manual, Chapter 5. And as always, we would recommend that you consult with the district's legal counsel regarding any proposed real property transaction. Next slide, please. Okay, frequent issues, mortgage liens and other encumbrances. When property is titled in the name of the finance corporation and not the Board of Education, that's a red flag. The district will need to consult with its fiscal agent and bond counsel to identify any actions that both of those may be required to resolve and provide clear title to a potential buyer. Donations. The donation of school property for public purpose other than the benefit of public education is not permissible. Any transfer of surplus school buildings or property to community service organizations or anybody else for that matter must be based on the fair market value of the property. That's based on Attorney General Opinion 9185. Leasing, as we touched on earlier, the value of the lease must be based on a factual determination of the services provided if you're using the equivalent valuable consideration. Next slide, please. Okay, questions and answers. Marcus.
Well, we don't have any questions and answers posted at this time.
Okay. Well, I'd like to thank everybody for their participation. Remind you that on December 11th, we'll have webinar number 5, which is going to touch on the basics of FactPack. As you can see, that's a very important component to what we do, both in construction and now property, as we've migrated property transactions to FactPack for record keeping purposes. We appreciate your participation today, and hope everyone has a great Thanksgiving. Thank you.
Hang out another minute just to see if anyone has any questions that they can think of. All right, if we don't have anything, I'll go ahead and end this event. As Greg said, we thank you for your participation.
Thanks, everybody.